This is judgment.
Sorry, I'm so sorry. In my case,
Alright, how many are for mentioning?
My lord.
Tell me one thing, all partial working days, there are at least 3 to 4 benches available. All urgent matters will be heard.
I want my matter to be heard on day after, because if the order is on the 30th, it will become insured. So
No, it's all right. Those who have an extraordinary urgency for day after, please give your letter of urgency. We will examine and we'll list those matters. Rest, all other matters will be listed in the very first week.
That's right. We'll do that, Lords.
Some peculiar.
My lords, my mentioning was allowed on Monday. Certain defects. I closed it right now. My dealing person was on leave. I closed it right now. My lords, I have an apprehension. My case will go into insolvency.
Mine is a regular bill management.
Okay, mine is demolition. Demolition date is 30th. Yesterday I mentioned before your lordship. I removed the defect. Now it is SLP number 19250 2026 on Friday.
There is some issue of caveat proof or something you have to put.
That we are done. We are done. Lordship.
If that is done, then we will list.
There's one matter
My lord.
may I submit, my lords? In my matter, the petitioner is in a critical position. Right now, bedridden with hospice care at home. So, my lords, she may not be able to see the listing of this matter post vacations. If your lordship would kindly.
We hope that you must have mentioned all these reasons. Oral mentioning will not serve. If you have mentioned anything attached to, so we'll examine. We are saying so.
I'm obliged. There's one matter, my lords. Would your lordship just
Any good reason for urgency of this nature that the matter must be heard day after, please give it, we'll examine it.
I'm obliged.
Otherwise, all matters of, in any case, routine urgency, within 2 days are to be listed, subject to curing the defects. 2 days means in the week commencing on 1st June onwards, we will list it. But if you have any special week that you want not on instead of 1st, we can adjust that much also. There is no.
My lords.
I'm so sorry, my lord. May I?
Only one request, which may not fall within usual urgency. We issued notices on the challenge to the
Take the mic, please.
to the transgender sect. My lords have issued notices. No, there are 3 or 4 high courts also where petitions are filed. We have filed transfer petitions. Now, in the high court, those matters would be coming in the first week of June, because some high courts are reopening in the first week of June. So, if the transfer petition, my lord, can be listed on Friday, my lords.
On?
Friday, my lord. Only transfer petition, because same act is challenged in high court also.
You know, it's not a small matter that they will be able to decide in a day or so. Assuming they decide, we will have the advantage.
There are some, my lord, interim orders being praised, etc. my lord. Even if a notice goes, my lord, we will be able to say that please wait till the Supreme Court finally adjudicates.
So that very act is under challenge.
The very act, my lord.
But sometimes we have the advantage of the High Court opinion also.
Well, there are 4 high courts where the matters are pending. There would be divergence of views. It's better, my lord, that your lordship finally can.
To help us in taking a correct view.
My lord, we may persuade your lordship, my lord, if it can be listed on Friday.
We'll see.
Please.
My lords, mine is listing today, my lords. This is a challenge to the CBSE's 3-language policy. My petition is already numbered. These are petitions by EVS category students and their parents. If they can be taken up with item 46, my petitions are already numbered.
Lord, I am appearing there, but there Delhi High Court is seized of this issue. There is a 226 petition challenging the same policy. We'll point it.
My lords, if my petitions can be called out, otherwise I have copies of my
To
petition.
be here,
Please, ma'am.
it will be very difficult for the registry also to process it.
I have copies also.
You may be here, if any
Please.
additional point, we can hear you also. Not
Grateful.
Because there's a matter where we'll provide the mentioning memo for Friday. Judgment rendered yesterday. I was on interim bail. My regular bail has been rejected. I've been directed to surrender within 3 days. Because I'll request for Friday. I'll place that mentioning memo before your lordship's done.
No, what is the urgency?
But the urgency is this. I was arrested on 23rd of December. Within 4 days, out of abject falsity of the matter, I was granted interim bail by the courts from 27th of December. That interim bail was continuing. Yesterday at 7 p.m., the judgment rejecting my regular bail has come out, and I've been directed to surrender. I am most.
I Item 27, the lordship, there are applications for withdrawal. This is at Himanshu Singh matter, lordships.
Item?
27 today, your lordship. My matter, your lordships could not be.
wants to.
It's not listed. It's tagged with it, but not listed. I'm just asking them to call for the file at 27. We'll be here at item 27.
You want to withdraw that?
Yes, your lordships.
In any case, we allowed, what is is it conditional withdrawal?
Condition is complete payment, your lordships. We are doing that. So lordships, the registry may just send the file to your lordships. Item 27.
Because we have taken.
That's the reason I'm requesting your lordships to call for the file, because your lordships, it's a standalone. There's only one homeowner. There's nobody else in my project. That's the reason. So if your lordships just directs them to call for the file, we'll address your lordships at item 27.
We'll see that there is no urgency for withdrawal today itself.
Your lordships, because the scheme ends on 30th. That is the reason. On 29th.
But
We'll be here, your lordships, at 27.
This year, we have some very serious doubts on the.
Yes, your lordship.
Why somebody is withdrawing that? Must
Yes,
be
your
because
lordships. So,
builder network must be working.
yes, that's the reason why your lordships has to look at it. So I'm requesting them to just bring the file. We'll show to your lordships what it is. Yes, grateful.
Your
Honor, with due
make a
permission.
mention, Malaj. Malaj, the Bihar municipal elections, Malaj, the elections have been held without the appointment of a backward commission, Malaj, and the seats have been reserved, Malaj. This is pending since 2024.
Election have already been held.
Yes, Malaj.
Then what is the urgency, please tell me?
Malaj, the urgency is that it is on the brinks of being rendered infructuous because the term is going to end in 2027, Malaj.
We will see, please. Don't
Malaj,
create
if your lordship,
artificial urgency.
Malaj, your lordship are sitting in the third week, Malaj, if your lordship may have it.
How can do you expect that all matters can be heard
Malaj,
in?
thrice, Malaj, this Malaj has been listed, Malaj.
We will see what is the.
Malaj, I'll just pass on the Malaj, the urgency letter. Yes,
We will examine it.
I'm so grateful, Malaj.
Football Federation matter. So we are one of the clubs who has been delegated in the
All India?
All India Football Federation. Lordship, in this case, we are one of the clubs who has been delegated.
All luxury litigation.
Lordship, I only request that we should be implemented and
All this
apply for
process. So what is the urgency now?
the urgency, Lordship, we have been already relegated. Now we can't participate in next season. We can't have any investors.
We will see what can be
We
done.
move the urgency for both implement as well as direction, Lordship.
We will see. This can be added during occasions also, no difficult.
Lordship, with due permission, I want to submit in one press matter, Your Honor, where the Dr. Suraj Singh has mentioned that a demolition has been, Your Honor, my petition is the connected matter, Your Honor.
All right, that can be listed, but
Yes.
there was issue that some caveat proof was required. Some there is.
Your
some
Honor, that has been cleared, Your Honor.
Please comply with that. Those both matters can be listed there.
Yes, sure.
Your Lordship, this is a civil appeal against NCLAT order and the NCLT order of CRP remains operative. We had mentioned on Monday it was to be listed today. However, the dealing person who had to check our appeal was on leave, so it could not be get cleared and mentioned. So it's requested that it may be listed on 29th because
Yes.
there's an imminent danger of going into liquidation.
May it please your lordship, my matter is similar. I also want to list my IA for withdrawal in Prakash Singh versus Union of India, which is item 54.
In Prakash Singh was Union of.
Yes, we have filed an IA for withdrawal of intervention application by IA number 159602.
Who is the applicant?
We are the applicant. We have
What is your status? Who are you? Just we want to know. Are you in Prakash Singh that DGP matter?
DGP matter, my lord. He moved application for IA for
Who is
intervention.
the applicant? We want to know that.
Sandeep Singh Rathore, my lord. Sandeep Singh Rathore.
Some individual is there.
Individual person. We want to withdraw the
What
matter.
he was asking for earlier.
My lord,
What was the relief he sought earlier?
during that point of time, my lord, his name is not in the panel list, my lord. For that,
Wanting consideration.
my lord, for we all now the name is included. My lord, his name is included. So we want to withdraw the IA, my lord. That's it.
All right, all right. Whenever it will be listed, we'll.
Right. Prakash Singh is listed today, my lord. My IA is not there. Even I wrote a letter to the registry to withdraw.
Prakash Singh matter is not listed, sir.
54, my lord.
If it is
54, my lord.
item 54. Because main case is not only Manipur IA is there because they have last 1 week they are making some mentioning about
urgency.
Just a withdrawal, my lord, may be allowed, may taken up a board and withdrawal, my lord, that's all.
Your application note earlier should have mentioned it. We can't take up along with this. We'll see.
Otherwise, direct the register, it may be listed because the registrar court, my lord, registrar will allow the.
The particulars of your IA will see.
Yes, always.
Lordship, my lordship, in petition 581, we have filed a co-option proposal. We have given a mentioning letter also, but they are not listing it then. So 29th, Vardhan matter is listed.
Bar council matters are over now. What?
No, my lord, Vardhan matter is listed on 29th. It's showing 29th.
We will see along with other matters. We'll take up.
Millards, may I mention, Millards, one listing of a fresh review petition, because I have to I was supposed to surrender in 1 month.
Do the mic.
And Millards, actually my bail application, I was granted bail by High Court, and this honorable court had thereafter directed them to rehear the matter. Now I have filed review petition and I have to surrender in 1 month. So Millards, 1 month will be expiring in June, so I have filed a review petition.
So which bench has passed the order?
Millards, Honorable Justice Pankaj Mittal and one more, Millards, I do not remember, Millards.
No, you are asking review in a criminal matter. We don't know.
I have, Millards, review has been filed, but defects have been not marked. So, Millards, may direct the registry to get it expedited and listed thereafter.
It will have to be circulated only. Review is not listed in open court. Unless the bench will direct.
Please, Millards, so at least can be listed either before the chamber court or circulation. I have moved an application for open hearing also.
Before the same bench.
Grateful, Millards.
With due permission, I want to mention an urgent listing of the matter on 29th. It's a land acquisition matter, Your Lordship. The High Court in the contempt proceedings is going to frame charges against the acquiring body officer on 4th of June. Your Lordship may kindly allow, the matter has already been cleared. All the defects have been cleared.
Who are you?
I'm the acquiring body officer of the acquiring body.
Then why the High Court has summoned?
Your Lordship, the entire decretal amount has already been deposited and it has been dispersed.
Explain to the High Court.
Your Lordship, we have already explained they are proceeding against the.
Going to file an affidavit of compliance.
They are taking a different.
Sorry, there is no urgency.
Lordships, my apologies. May I mention 28, 25 and 25.2, which is listed today. Both were taken up on 4th May and Lordships had given a date for 21st of July. I'm just requesting if those can be listed on 21st itself. There were a date given matter. There were time for the Lokpal to file a rejoinder and complete pleadings.
Piece of paper, you can write down that same matter to be on 21st July.
I'll do that.
Lordship, if I mention a matter, with your Lordship's permission, may I mention a matter? It's an anticipatory bail matter, my lords, for offences under 504 and 506. The subject FIR was a cross FIR. We have filed on 24th. We have cleared the defects yesterday only, my lord. However, the registry has not cleared it. That's why it could not be listed, my lords. If my lords can allow it for the listing on Friday.
Why it has not been listed? There must be some reason.
We have cleared the defects. However, they have not cleared, the registry has not cleared it. That's why it was not cleared for the listing, my lord.
We'll check up.
Grateful.
501 for adjustment.
Please, that batch of petitions instituted under 32 of the person assailing the impugned order directing SIR in Bihar. Then we have shortlisted the controversy that the controversy emanates from the issuance of the impugned order by the Commission in purported exercise of its powers under Article 324 of the Constitution, that is Section 21, subsection 3 of the Representation of the People Act 1950, directing an SIR of the electoral rolls in every assembly constituency of the state of Bihar. The impugned order reported that the last intensive revision in the state of Bihar was conducted in 2003, and that over the past 2 decades, substantial changes in electoral rolls have occurred entirely on account of rapid urbanization and large-scale migration. Therefore, in furtherance of its constitutional mandate to safeguard the integrity of the electoral rolls and ensure free and fair election, the Commission resolved to undertake the nationwide SIR. Given that general elections to the Bihar Legislative Assembly were anticipated later in 25, the Commission directed the conduct of SIR in the state of Bihar. Then we have after the referring to the rival contention from both sides, then we have said that having traversed the sequence of events as they emanated, the contentions put forth on behalf of the parties as well as material on record, we are of the consideration that the following issues require analysis. First is whether the Election Commission of India has power to conduct the impugned SIR. Second, whether the impugned SIR is founded on a legitimate purpose, and if so, whether the measures adopted by the Election Commission are proportionate to the object sought to be achieved. Third is whether the procedure adopted by Election Commission in conducting the impugned SIR is contrary to or in violation of the provisions of the Representation of People Act 1950 and the registration of Electoral Rules 1960. The fourth question is whether in the exercise of its constitutional mandate of preparation and maintenance of electoral rolls and in furtherance of the statutory conditions governing such registration, the Election Commission of India is empowered to scrutinize the citizenship status of persons seeking inclusion or continuation in the electoral roll. As regard to the first issue, whether the Election Commission of India has power to conduct the impugned special intensive revision, we have considered the contentions and then our brief findings are that having deconstructed section 23 and examined the import of the consequent expressions, we may now proceed to answer the limited question formulated earlier by us, namely whether the impugned order is in direct conflict with the RP Act and the 1960 rules and whether in its operation affects the directly affect the RP Act and the 1960 rules and whether its operation and effect it subserves the constitutional goal of free and fair elections. In our view, both limbs of the question must be answered in favor of the Commission. Far from acting in defiance of the RP Act and the 1960 rule, the Commission has clearly anchored its actions in a specific enabling provision designed by Parliament for exceptional exigencies polluting the electoral process. Section 21(3), couched in terms materially distinct from 21(2), authorizes the Commission, notwithstanding the ordinary regime of revision, to direct a special revision at any time for reasons to be recorded and in such manner as it may think fit. Once the statute itself carves out that special field of operation, the impugned exercise cannot be invalidated merely because it does not conform in every respect to the ordinary modalities contemplated for revision under section 21(2), read with rule 25. In our considered opinion, the impugned SIR does not supplant the RP Act or the 1960 rules. It rather breathes life into the constitutional mandate of Article 324 through the precise statutory conduit provided by section 21(3). Therefore, it cannot be said that the Commission has acted in the teeth of an express statutory prohibition. So long as the Commission acts within the bounds of the statute, records reasons for recourse to the special power, and does not transgress any express prohibition contained in the Act or the rules, the exercise cannot be struck down as ultra vires merely because it adopts a procedure different from that applicable to ordinary revision of electoral rules. We are equally satisfied that in its object and design, the impugned SIR bears a direct nexus to the constitutional goal of a free and fair election. Free and fair elections do not rest merely upon the mechanics of polling. They equally depend upon the integrity, accuracy, and purity of the electoral roll, which forms part of the foundation of the democratic process. The reasons reported by the Commission, namely the passage of more than 2 decades since the last intensive revision, large-scale additions and deletions over the period, rapid urbanization, migration, and the resulting possibility of repeated or defective entries are plainly directed toward preserving that foundational integrity. The impugned SIR, therefore, is not a process designed to subvert the established procedure, but an intended to secure the constitutional mandate of free and fair elections. For the aforesaid reason, we hold that the impugned SIR neither stands in direct conflict with the RP Act and the 1960 rules, nor does it detract from the constitutional imperative of free and fair elections. On the question number 2, whether the impugned SIR is founded on a legitimate purpose and if so, whether the measures adopted by ECI are proportionate to the object sought to be achieved, we have considered this aspect in detail and we found that this question needs to be divided in 4 sub-questions. In view of the rival submission, the advance on behalf of the parties, the following 4 questions arise for consideration with respect to the proportionality of the impugned SIR exercise. First is whether the impugned SIR is founded upon a legitimate purpose consistent with the constitutional and statutory mandate of the Commission. Second is whether the means adopted by the Commission bear a rational nexus and the object sought to be achieved. Third is whether the measures undertaken were necessary in that there are no alternative measures that can achieve the same purpose with a lesser degree of limitation. And fourth, is there a fair balance between the importance of achieving the proper purpose and the limitation it places upon the constitutional right. Then all these 4 issues we have examined in detail, reaching to a conclusion to say that the proportionality of a measure must ultimately be assessed not in the abstract but in the manner in which it is implemented, a process that may be perceived as exclusively by some can, through appropriate safeguards, be rendered constitutionally compliant in execution. In the present case, the cumulative effect of the safeguards introduced both by the Commission and pursuant to the directions of this court. We have before that dealt with all interim directions issued from time to time, and pursuant to the directions of this court has been to strike a balance between the need for electoral integrity and the imperative of inclusion. The process, as it ultimately unfolded, provided multiple avenues for participation, correction, and redress. We are therefore of the conclusion that the impugned SIR has conducted satisfy the requirements of proportionality. The measures adopted bear a rational nexus to the object sought to be achieved, are not manifestly excessive, and are accompanied by sufficient procedural safeguards to prevent arbitrary exclusion. In view of the foregoing analysis, we hold that the impugned exercise was founded upon a legitimate and constitutionally grounded purpose, namely the restoration of accuracy, completeness, and integrity of the electoral rolls. We further hold that having regard to the nature of the problem sought to be addressed, the scale of the exercise undertaken, and the procedural safeguards incorporated during its implementation, the measures adopted by the Commission cannot be said to be disproportionate to the object sought to be achieved. On the third question, namely whether the SRA is contrary and violative of provisions of the Representation of the People Act 1950 and the registration of the Electors Roll 1960, we have said that having held that the impugned SIR is legally tenable and pursues a legitimate purpose, we now proceed to examine whether the procedure adopted by the Commission is in derogation of the provisions of the RP Act and the 1960 rules. This question also we have subclassified in 3 categories. That we have said that 3 principal grounds have been asked before us by the petitioners, namely 1, the electors whose names are already entered in the electoral roll are entitled to a presumption of citizenship, which cannot be displaced save in accordance with procedure established by law. 2, that the procedure contemplated under Rule 21 capital A of the Registration of Electors Rule 1960 has not been followed. And 3, that the documents prescribed by the Commission for the enumeration of the electors coupled with the exclusion of previously accepted documents are arbitrary and without any reasonable justification. Then we have analyzed these 3 categories. We have also dealt with Lal Babu Hussain from para 108 onwards. And we have ultimately concluded that we are also unable to accept the submission that the undertaking of an intensive verification exercise ipso facto reverses the burden of proof in a manner impermissible in law. The calling upon electors to furnish supporting material in course of such an exercise does not amount to the negation of the presumption. Rather, it reflects the procedural mechanism through which the Commission seeks to reaffirm or, where necessary, correct existing entries. The presumption continues to operate, but it does not obviate the possibility of verification. It is also significant that in Lal Babu Hussain, this court did not hold that the presumption attaching to an entry in the electoral roll is irrebuttable. On the contrary, the very recognition of the presumption implies its susceptibility to being displaced upon appropriate inquiry. What the judgment underscores is the need for adherence to procedure and fairness in the process of displacement. It does not foreclose the existence of such a process altogether. And after that, we have said we are thus of the considered view that while inclusion in the electoral roll gives rise to a presumption of validity, such presumption is rebuttable and cannot be construed as imposing a blanket embargo on the powers of the Commission to undertake a special intensive revision. The decision in Lal Babu Hussain does not compel a contrary conclusion, being confined to the extent of adjudicatory proceedings. With respect to Rule 21A, also then we have given a detailed discussion, and then we have concluded, viewed holistically, the scheme underlying the SIR guidelines revealed that the safeguard embedded in Rule 21A of the 1960 rules have not been abrogated but are instead crystallized within a broader and structured revision framework. The essential elements of Rule 21 of the 60 rules, namely identification of doubtful entries, publication of such cases, notice to the concerned elector, and a determination after considering objections, find clear reflection across the various stages of the SIR process. The form may differ, but the substance remains intact. In particular, what Rule 21A of the 60 rules contemplates as a singular event-specific exercise of deletion is under the SIR framework distributed across multiple procedural stages, beginning with enumeration, followed by draft publication, and culminating in the claims and objections process. It is at this later stage that the core safeguards are activated. The elector is put to notice and inquiry is undertaken where doubt exists, and a reasoned determination is made. The requirement of affording a reasonable opportunity to show cause as envisaged in the proviso to Rule 21A of the 1960 rules thus stands fully incorporated. It must also be borne in mind that the statutory framework does not mandate a rigid or singular procedural format for all situations of deletion. What it insists upon is fairness in action. The SIR guidelines in incorporating notice through publication, individualized inquiry in case of doubts, a speaking order, and a right of appeal satisfy this requirement. To construe Rule 21A of the 1960 rules as requiring a uniform pre-decisional notice at the very threshold, irrespective of the structure of the exercise, would be read the provision in unduly restrictive manner. We are therefore of the considered view that the deletions effected pursuant to the implemented SIR cannot be said to be contrary to the procedure prescribed under Rule 21A of the 1960 rules. The safeguards of notice and hearing are preserved in substance, and the process adopted by Commission remains within the bounds of the statutory mandate. Then we have dealt with the validity of the documents regime prescribed by the Commission as part of enumeration exercise. After dealing with those 11 documents which they said, and after referring to the inclusion of Aadhaar card through our order passed in detail, then we have said we have bestowed our careful consideration upon the rival submissions advanced on this issue. The challenge, in essence, is directed not merely at the nature of the documents prescribed, but at the authority of the Commission to structure a documentation regime as part of an intensive verification exercise. We are unable to accept the contention that the prescription of such a regime in the facts of the present case is arbitrary or dehoes the statutory framework. In that context, the prescription of the set of documents operate as a tool to ensure administrative consistency and evidentiary reliability. It is neither practicable nor desirable for the verification process to be left entirely unguided or subjective. It is true that Form 6, as prescribed under the Registration of Electoral Rules 1960, sets out a framework of documentation. However, the same is tailored to the process of revision contemplated in Section 21(2) of the RP Act and may not, in all situations, be capable of literal application to an exercise of the present nature, namely SIR, under 21(3). The Commission therefore retains a degree of residual authority to formulate an appropriate documentation framework suited to the exigencies of a special intensive revision. Such authority, however, is not unbounded. In devising such a framework, the Commission must remain cognizant of the existing statutory scheme, and any departure therefrom must be informed by a rational nexus to the object sought to be achieved. The formulation of the documents regime must thus reflect a calibrated balance in drawing from the statutory framework while adopting it when necessary to effectively serve the purpose of ensuring the accuracy and integrity of the electoral rolls. A perusal of the documentation framework suggests that the list of documents is indicative of materials that are ordinarily available to electors. The expansion of the list as compared to earlier exercises also demonstrates an attempt to widen the range of acceptable proofs rather than to restrict it. The argument that the regime is exclusionary therefore does not commend acceptance in the absence of material to show that the prescribed documents are by their very nature inaccessible. Then on the fourth question, the existence of the constitutional mandate of preparation and maintenance of electoral rolls and in furtherance of the statutory conditions governing such restriction, whether the election commission is empowered to scrutinize the citizenship status of the person seeking inclusion or continuation in electoral rolls. This part we have discussed in detail and come to the conclusion that in view of the statutory requirement under section 16 of the Representation of People Act, the Commission in the course of preparing or revising electoral rolls is undoubtedly empowered to examine questions bearing upon citizenship. However, such an inquiry can only be made from the standpoint of determining inclusion or exclusion from the electoral roll and must be undertaken with due regard to the presumption operating in favor of an elector whose name is already borne on the roll. It is within this confined statutory setting that the Commission assesses the material before it to arrive at a determination for electoral purposes. Importantly, the entirety of this exercise remains amenable to judicial review, thereby ensuring that the inquiry is conducted in accordance with law and within the bounds of the procedural fairness. We have no hesitation in adding that this assessment is necessarily prima facie and contextual, where the material furnished by an individual does not inspire confidence or give rise to doubt. The Commission is within its authority to decline enrollment or to initiate action for deletion strictly in accordance with law. Such action, however, must be understood in its proper perspective. It does not amount to a declaration that the individual is not a citizen of India. It merely reflects the Commission's inability to be satisfied for electoral purposes that the statutory conditions are met. The consequence of such a determination is correspondingly limited. It affects the individual's entitlement to be included in the electoral roll and thereby their right to participate in the electoral process. It does not, however, operate to divest the individual of claims of citizenship, nor does it foreclose a determination of that question by the competent authority under the Citizenship Act. Moreover, in cases where the Commission is not satisfied that a person meets the statutory conditions for inclusion in the electoral roll, it would be incumbent upon the Commission to refer such an individual to the competent authority within the central government for adjudication in accordance with law. The Commission's determination, being confined to electoral purposes, cannot assume finality on the question of citizenship. Any deletion effected on this ground shall therefore remain subject to the outcome of such adjudication by the appropriate authority. So based upon these questions to answer to the four questions, we have summed up by saying that the impugned SIR exercise neither stands in direct conflict with RPF and the 1960 rules, nor does it detract from the constitutional imperative of free and fair elections. It is instead an exercise traceable to section 21(3) of the RPF, read with article 324 of the Constitution, undertaken to advance the very objective of which part 15 of the Constitution is designed to protect. To the impugned SIR exercise has conducted satisfy the requirements of proportionality. The measures adopted be rational in access to the objectives sought to be achieved, are not manifestly excessive, and are accompanied by sufficient procedural safeguards to prevent arbitrary exclusion. The impugned exercise was founded upon a legitimate and constitutionally grounded purpose, namely the restoration of the accuracy, completeness, and integrity of the electoral rolls. Having regard to the nature of the problem sought to be addressed, the scale of the exercise undertaken, and the procedural safeguards incorporated during the implementation, the measures adopted by the Commission cannot be said to be disproportionate to the object sought to be achieved. While inclusion in the electoral roll gives rise to a presumption of validity, such presumption is rebuttable and cannot be construed as imposing a blanket embargo on the power of the Commission to undertake a special intensive revision. The decision in Lal Bagh Hussain does not compel a contrary conclusion, being confined to the context of adjudicatory proceedings and not extending to a systemic exercise undertaken in furtherance of the Commission's constitutional mandate. The deletions affected effective pursuant to the impugned SIR exercise cannot be said to be contrary to the procedure prescribed under Rule 21A of the 1960 rules. The safeguards of notice and hearing are preserved in substance, and the process adopted by the Commission remains within the bounds of the statutory mandate. The documentation regime prescribed by the Commission represents a considered exercise of its administrative discretion in furtherance of the Constitutional mandate. The classification of documents, including the exclusion of certain categories, apart from Aadhaar card, which were directed to be included by our order of 8 September 2025, is based on intelligible criteria having a direct nexus with the objective of ensuring the integrity of the electoral roll. We are therefore unable to hold that the impugned documentation framework is arbitrary or violative of the statutory scheme. The Commission is empowered in the exercise of its constitutional mandate to undertake a limited inquiry into the citizenship for the purpose of satisfying itself as to eligibility for inclusion in the electoral roll. Such an inquiry does not amount to a determination of citizenship in the strict sense, and in any action taken pursuant thereto is confined to electoral consequences alone. The consequence of such a determination is correspondingly limited. It affects the individual's entitlement to be included in the electoral roll and thereby their right to participation in the electoral process. It does not, however, operate to divest the individual of claims of citizenship, nor does it foreclose a determination of that question by the competent authority under the Citizenship Act. In cases where the Commission is not satisfied that a person meets the statutory conditions for inclusion in the electoral roll, it would be incumbent upon the Commission to refer such an individual to the competent authority within the central government for adjudication in accordance with law. The Commission's determination being confined to electoral purposes cannot assume finality on the question of citizenship. Any deletion effected on this ground shall therefore remain subject to the outcome of such adjudication by the appropriate authority. Then we have issued a further direction regarding persons whose names have been deleted from the 2003 roll on account of the Commission being of the opinion that they are not citizens. The Commission is directed to refer such cases within 4 weeks to the competent authority under the Citizenship Act 1955 for adjudication of their citizenship claim. The competent authority shall take the necessary decision in accordance with law, preferably before the next Parliament, Assembly, local body election, whichever is earlier, after giving notice and an opportunity of hearing to the deleted individuals, if any. In the event the competent authority holds that such deleted individuals are citizens, they shall be included in the electoral roll. In addition thereto, all persons who are domiciled in Bihar and whose names have been erroneously deleted on the ground that they are absent, dead, shifted, or in duplication, may also assail the decision of the Commission by way of judicial review. These petitions are accordingly disposed of in above terms.
We are grateful, Lords.
Item number 1. Excuse me, my lords.
Item 2.
May I please? I'm appearing.
With my lord's permission, I humbly request to mention a matter, my lords. My lords, I have filed an urgency application.
Yes, please.
My lord, these are 3 bail applications. Right? My lord had on the last occasion had directed my lords to, the DLSA to have my lord arranged lawyer for the victims. Victims were to be, my lords wanted to hear the victims.
What is the High Court has done? Reports have come from the High Court also, because the earlier order were not communicated. That's why the legal civil authority, probably there was some delay on their part also. Now there is another report that's quite disturbing that has been sent by the former Director General of Police, who is appointed by this court to monitor about some latest incidents that have taken place, unfortunately. This affidavit says on 7th April, some incident, some 2 innocent children were killed. Then in retaliation, they attacked the CRPF post. Then CRPF opened fire, killing 3 persons. Then prohibitory order. There are some issues. I think
Now the trial is trial is in process, my lord, as far as this case is concerned. And there is one,
remain intact.
my lord, there are 2 persons who are out, my lords, for which we have asked for, my lord's cancellation of bail. One, the third application is where he is asking for bail. My lord, now the trial was earlier not progressing because, my lord, they were taking time for forcing the witnesses to be present in the
That's a wrong statement.
No, I'm just saying.
That's a
something,
wrong
please
statement.
Wait for some time. Then after some time you can say. There are 3 problems that were happening. One was this. This is my instructions. 2, there is also a problem of, my lords, the translation from cookie language, my lords, because the translator was not available. And both reports have been trying to put it on.
Trial in Assam.
Trial is in Guwahati, my lords. So these are some problems, and there was applications where they said the victims were not ready to come to Guwahati. They insisted that for a better cross-examination. That is my instruction, my lords. Now, last occasion, my lords, the internet was down, so therefore, there is a Gemini order with me, my lords, where because of the internet was down and the entire state of Manipur, they could not join, my lords. 1 victim is already, my lord, examined. 2 victims are yet to be examined. My lord, my only thing is there are about 30 witnesses. I have instructions to say that on because cases listed every 15 days, 2 witnesses, my lord, 6 months to 7 months, we should be able to conclude the trial. If, my lords, these 2 persons, my lords, it will, my lords, help in the proceeding because there is a certain amount of, because there are some witnesses, my lord, there will be.
May I please, your lordship?
Wait, please. Wait.
Yes, sir.
No, but that may not be a good ground to cancel bail. There is no such allegation that.
There is no allegation, my lord. I must say it candidly. There is no allegation as of now. But, my lords, I only say.
Bail has been granted only because of the lapse of the CDI. That is paragraph 18 and 19 of the.
My lord, that is where, my lords, I will say it is not completely, my lords, correct because 2 reasons. There was, my lord, the sanction was taken some time. There are other issues which took some time.
Mr. DPC, we don't want to keep it pending in order to hear against the grant of bail. We are only keeping it pending for the larger issue because with a view to facilitate the victims. That's why we have issued certain direction to the state legal authority.
May I please,
to provide lawyers who can understand their language, who are local counsel and local dialect, they can talk to them. Similar problem not only with the victims or their families,
even the
problem with witnesses.
Witnesses also, my lord.
So we will probably for this limited purpose will continue to monitor. Rest of the issues will not interfere. Let us see that how the trials proceed because trials also need to be expedited in this matter.
Yes. Lordship,
Can my lords only observe with this regard, my lords? I understand, and I'll bow to what my lords have said. except that, my lords, both the parties will cooperate with the trial, my lords, and will not take, and will not delay it. We will also try, my lords.
So see, you are the prosecutor.
My lord,
You have to ensure the confidence building measure in the victim.
we are doing that, my lords. We are doing that. Actually, my lords, a person goes,
Sending them back to jail really does not inure to any benefit until and unless there is a speedy conclusion to this trial and confidence
I'll bow, my
is
lords.
restored.
I'll bow, my lords. Let me not press it further. Let me not press it further, but at least for the conclusion of trial, my lord, let both parties cooperate. And my lords can at least, my lord, then
Lordship, I just
a word of caution that both parties will, my lords, cooperate. All, they will, accused will cooperate.
Cooperation do you expect? You have to give that
Unless
confidence
sometimes-
to the victim. We have transferred the case to Assam. Earlier orders direction that the two state legal services authority would provide them lawyers for representation. So now you have a bridge through the legal representation they have.
My lord, there are 4 or 5 parties now. It is not only the prosecution, DLSA on both sides, the intermediaries who are trying.
Nodal
So if
person.
once my lords have some kind of a, my lords, guidance with regard to that, my lord, then assistance getting, my lord, CBI getting assistance from all quarters is also as important for the purpose of conclusion of the trial.
So keen that the trials are concluded at the earliest because it's a question of victims and their families' faith in the system. That's more important. So therefore, the trials in any case will be expedited. But of course, as my brother says, that you have to create that environment, and they will also cooperate.
Yes.
Probably none of them is against.
A word from my lords will also help to do that also, my lords. I'm saying for all parties. That is, I'm insisting for all parties, my lords.
Lordship,
The logistical support for CBI is also as much important. A word thereafter, and if all parties will cooperate, we will, my lords, will then try. That is all I'm seeking.
Lordship, I appear for the victims, if I may just have a minute, Lordship. Lordship, just the on 9th of May 2025, the same court, considering the bail of the same accused, noted the heinous nature of the allegations in detail, how they have been identified in TIPs, etc., and how the nature of offences were barbaric, and denied bail. And just on 8th September, not even a full 4 months later, they are released on bail by the same court, saying that there is delay of 4 months, Lordship, and given the nature of what Lordship's report also says, the circumstances there. Lordship, this delay didn't amount to a reason enough to overturn the view that the same honorable court had taken.
Also challenging the grant of bail.
Lordship, our SLP has not yet been filed, but I have instructions to file and we're just awaiting. Lordship, please.
Be really impressed by the way in which the High Court has granted bail. After all, it is a question of liberty. That is why it would require a very egregious situation coupled with a threat perception on the victims, which would persuade us to cancel it.
Lordship, please.
At the same time, what we have indicated to Mr. Singh, our main concern is bringing home the truth through the judicial adjudicatory process.
Lordship, please.
And for that, whatever support, confidence, and rehabilitative measures necessary, we are inclined to examine this petition from that perspective and ensure a clear conclusion on the finding of guilt or innocence of these accused.
So,
It
Lordship,
becomes really no purpose to quibble over these interlocutory exercises of grant of bail or not. Finally, it matters is whether the prosecutor is able to conduct a fair trial and thereby a just conclusion with regard to guilt or innocence.
Lordship,
The cooperation of the victim, and that is our main focus.
Lordship, just a propose what is falling from my Lordship, just 2 points. One, Lordship, 3 named accused in the FIR who are accused of very, very egregious acts of sexual violence and murder. One Loya, one Chinglen, and one Inauton. Lordship have not yet been arrested. Lordship, and if Lordship remembers, I don't want to repeat the incident. Lordship remembers that these victims had taken refuge in a police vehicle, and the police man had taken the key and left them to the morgue. Lordship, no action taken against the police persons. It's not a,
These 2-3 names.
these 3 persons are still absconding, and so there is a threat perception. And lots of the policemen who are very easily identifiable, who had left the victims to the mob because they sought refuge in a police vehicle, and the policemen took the key and left them to the crowd along with the vehicle.
Mr. Pasha.
Lots of no action is being so those.
Mr. Pasha,
Lots of please.
these persons have been declared as proclaimed offenders.
Lots of please.
The trial has proceeded in respect of the persons who were there, and it is at the stage of recording of evidence.
Lots of please.
In the event, the victim's evidence clearly disclosing larger conspiracy or involvement of other persons, including men in uniform, are placed on record, I think Mr. Singh's client are well equipped to get directions for their being arraigned as accused person. But if you, in that perspective, want us to pursue the absconding accused, then the most vital evidence, which will be the fulcrum for prosecution to convict individuals, will be delayed.
And
which do you propose?
And that is why 299 was taken.
Just on Lordship,
This
the
is the
non-arraigned.
confidence building measure we were talking of.
Yes, my lord.
The victims remain traumatized.
Absolutely.
Right. So you have to give the guidance and the correct direction to the trial. That recording of the evidence in a clear, full disclosure of who are involved, who are not involved, whether they are charge sheeted or not, should be before the court. Then you can take your steps if necessary.
Precisely.
The no investigation against the police personnel is also impacting the confidence of the victims. So that is a lacuna in the investigation, because there's been no investigation by the police personnel so far.
No, they are not party to the. They are not party to the case. They may be party to dereliction of their duty, but they can't be associated.
Whatever is Mr. Pasha's client's views, that is the deposition of the victim.
Yes, ma'am.
If that aspect has not been covered by the investigating agency, prosecuting agency, at this stage, it would be for the trial court to examine the evidence with regard to complicity in abetment, complicity in conspiracy, or, as Mr. Singh indicates, maybe disappearance of evidence. Whatever is, that will be the trial court's call. Now, if you want the hand of the clock to be sent back, what would happen is the most important step would be postponed. That is the recording of versions in court.
Very well, Lordship.
Your Lordship, I beg to appear for the petitioner in item 2.2. Lordship, my client is behind bars. I'm seeking bail on merit, Your Lordship.
February 2026 and 24th March 2026. The High Court of Manipur has filed status report, inter alia pointing out that registrars of both the High Courts, namely the Manipur High Court and Guwahati High Court, as well as member secretaries of the state legal authorities, have established communication to facilitate the provision of legal aid to victims and their families. Semicolon, a virtual conference was held between them on 30th March 2026, followed by a physical meeting on 1st April 2026, in which the Advocate General of Manipur, former Registrar General Manipur High Court, and Member Secretary and other senior officers of the CBI and police, as well as Anti-Corruption Bureau, participated. They charted out a structured course of action for the appointment of legal aid counsel, from a supply of charge sheets, from addressing impediments such as travel, boarding and lodging, etc. Next paragraph. On 6th April 2026, a virtual conference was held with their Assam counterparts to ensure that the legal aid counsel are appointed from both states for the victims and their families, and the necessary steps for such appointments have since been taken in 26 cases. Then main paragraph now. Mr. Dattatreya Padsalgarkar former Director General of Police Maharashtra, who has been appointed by this court to monitor the ongoing investigations, has also filed his 13th status report, inter alia pointing out that there is the law and order situation is quite precarious, as new incidents of violence have taken place on and around 7th April 2026 and again on 18th April 2026. He has summed up pointing out that due to bunch, torch rallies and sit-in protests, due to increase in bunch, torch rallies and sit-in protests, the state police is stretched to its maximum. Next paragraph. CBI has also filed a status report to the effect that 20 charge sheets have been filed. Instead, there are 21 cases. There are 21 under trial cases. That is 13 before the special judge for CBI and NIA Guwahati, and 6 cases before the Chief Judicial Magistrate Kamrup Guwahati. Trials have commenced in 16 cases at various stages. Meanwhile, another complaint was received. No, don't say meanwhile. As regard to the complaint which the CBI had received on 22nd July 2024 regarding 2 missing students, the CBI has explained that despite 5 suspects have been arrested and the investigation is still ongoing, the bodies of the missing students have not been traced so far. Next paragraph. As regard to the status report filed by the SIT, it is pointed out that charge sheets have been filed in 297 cases against 414 accused. However, the trial has only commenced in 10 of those 297 cases only. Some meetings have taken place in recent times in order to expedite the ongoing trial and for appointment of the additional special public prosecutor. Next paragraph. Another report number 45 and 46, May 26 and 25th May 2026 have been received on behalf of the 3-member committee headed by Justice Geeta Mittal, former Chief Justice of the High Court. The said report Ontario provides as follows. Ontario provides as follows. Next paragraph. We have briefly heard the additional social material on behalf of the CBI as well as one counsel for the respondents. The both sides have clearly suggested that the ongoing trials need to be expedited. We therefore impress upon the CBI and all other stakeholders to provide especially the state legal authority, to provide legal aid counsel to arrange the provide legal aid counsel who are well conversant with the Manipuri or local language stroke dialect and who are able to speak, able to interact with the victims, stroke their family as well as the witnesses. witnesses. This will provide immense help in explorating the ongoing trial. It goes without saying that the both sides will also extend full cooperation in this regard. That if the status report the ongoing trials be along with details of the witness examined or left to be examined, be filed before the next date of hearing. Post these matters on considered.
Your Lordship,
Lord, may I file the counter affidavit in the reply?
Even counter affidavit can be also filed.
Obliged.
Your Lordship may take up 2.2 separately. My client was denied bail, Your Lordship. He was 18 years old when he was arrested. The only role ascribed to him was that he's in the mob and he recorded a video.
That will remain inside.
Your Lordship,
That was not the only role.
3 years.
That was his role was participation, and in addition to that, the video which brought this to the fore, he recorded that and circulated that widely.
Identified by all the victims also.
Your Lordship,
We will see later on.
Your
Lordship,
Lordship, just for 3 years, the other co-accused are on bail. Whoever much more heinous.
Lordship, just one. Lordship may consider, and so far as the other SLPs are concerned, Lordship, until the statements of the victims are recorded, Lordship consider let them be inside. And then Lordship can consider after the statements are recorded, because that's a typical order that Lordship passes, that once the statement of victims is recorded.
If there is any material information or allegation comes of their tinkering with evidence or influencing any witness, then you know the ground, then we will immediately take it. So long as they are within they understand the implications and they don't misuse it.
The state and the trust.
Also, direct as an abundant precaution to the CBI as well as both the state governments.
May I please, my Lord?
To
I'm so
ensure
grateful.
compliance of the victims' protection, to ensure the compliance with the victim protection scheme. So that's protection.
Victim and witness protection.
Schemes.
For the victims and their family. They are victim.
Family. Or other eyewitnesses or other vital witnesses.
I'm grateful, Lordship, extremely grateful.
All right. May I, grateful.
Lordship.
Will your Lordships consider the bail on the next date for 2.2, Your Lordship?
Lord, in item 3, I'm seeking for a pass over, my lords. Mr. Sybil is hearing in the matter, my lords. I'm being led by Mr. Sybil, my lords. I'm seeking for a pass over, my lords.
So we have it after vacation, Lord, then.
All right, item 4, next.
Wait,
Take a vacation paper.
Please, Lordships. 3 times when the Supreme Court has intervened, there was no recommendation. Concrete proposal has come as indicated by my lord in the last order, my lord. No concrete proposal has come for safeguarding the.
We will see,
Please, my lord.
Item 4.
Yes, my lord. My lord, I am confining my prayer only to the prayer number 1 in the writ petition, my lord. And Lordship, may see at page 55, the rule, my lord, which was introduced.
Whatever suggestion, these are all highly technical things you are.
No, Lord, no personal. I am not challenging any election.
No, it's
only
quite
fair.
a good thing.
What he is saying is,
In favor of it, it should be. But if please represent to the election commission, we will direct them because it's involved some technical aspect. They will have to see that how it can be ensured.
No, just to assist my learned friend, my lord. All the 3 times, my lord, where your lordships, my lord, have put in place this VVPAT and, my lords, improved upon its efficacy and transparency, my lord. Your lordships, my lord, took the initiative. So, lordships, my lord, the election commission. So, therefore, my lord, lordships may call upon the election commission here because we are not challenging any, my lord's election. And we are only saying that the guidelines should be prospective. And, my lord, what we are only asking, my lord, that when the VVPAT slip comes up, my lord, the time stamping should be done. So that, my lord, now there are a lot of allegations that, my lord, after 5 p.m., my lord, there is a sudden jump up of votes, etc. All that will be put to rest, my lord. So therefore, your lordships may kindly call, my lord, because representation and then decide.
We are doing the same purpose, we will just direct the commission.
My lord, in all,
Yes,
what
just
I was
recently
only- yes, my lord, what I was only suggesting is, my lord, I have put all the judgments on record, my lord. All the 3 times your lordships never pushed us back to the, my lord, election commission. Lordships may call upon them, my lords, and then ask for a reply, my lord, whether it can be workable or not. That's my respectful submission.
Lordship can treat this writ petition as a representation, we'll submit it.
But because you don't go to even commission, that the
Yes,
whole problem
that's
is
a
this.
shortcoming in this writ petition, therefore, my lord, we are making a
Everybody directly come to us, that is.
Yes, my lord, that's a shortcoming, my lord, therefore, my lord, this impediment, my lord, lordship may treat this writ petition as a representation, my lord.
Instead, the petition under Article 52 of the Constitution has been filed purportedly in public interest. The petitioner claims himself to be a businessman and philanthropist, though no such details have been provided in the writ petition. That's why, be that as it may, the prayer in the instant petition revolves around the systemic enhancement of electoral transparency by mandating the time-based stamping of votes on voter verifiable paper audit trail in bracket VVPAT bracket close slips. The petitioner contends that while Rule 49 capital M of the Conduct of Elections Rules 1961 specifically mandates that VVPAT slips display the candidate's serial number, name and symbol, it notably omits the exact time of the votes recording. This omission, according to the petitioner, creates a significant physical audit gap. As per that, the petitioner has thus argued that while addressing timing-based complaints such as late hour voting surges, turnout revisions, or booth level discrepancies, the physical paper trail itself remains silent on the exact time at which the vote was cast, rendering its evidentiary value weak. Rendering it evidentiary value weak. The petitioner has also cited on illustrative basis certain instances where large-scale last-minute voter turnout in 2024 in some of the states in the previous elections. That's why it is in this backdrop that the petitioner has sought a direction to the Election Commission of India to suitably modify the existing VVPAT related guidelines, manuals, instructions, and standard operating procedures by mandatorily incorporating a provision for printing the exact time of recording of each vote on the corresponding VVPAT slip. The petitioner also seeks a direction that the exact time stamping on VVPAT be implemented in a manner that preserves complete secrecy of voting and shall not include the voter's name, APIC number, electoral roll number, Form 17A serial number, or any other identifying particulars of the voter. The petitioner then seeks another direction to ensure that all VVPAT slips, including time-stamped VVPAT slips, once implemented, are preserved for a minimum period prescribed under Rule 94 of the Conduct of Election Rules 1961, and beyond such period where any complaint, a request for verification, election petition, or any other court proceedings have been initiated. Next paragraph. Having heard launching a constituted parties for the petitioner came up. It seems that the issue raised by the petitioner is in furtherance of the electoral reform.
Integrity of the electoral
Transparency. Fairness and transparency.
transparency, accountability.
The election process. However, the prayers made by the petitioner, whether are feasible to give effect or not, is essentially a technical and policy issue, which is required to be considered a technical issue that falls within the domain of the Election Commission of India. Consequently, we dispose of this petition without expressing any opinion at this stage. With a direction to the registry to forward a copy of the entire paperwork to the Election Commission of India, which shall be treated as a representation on his behalf. Shall be treated as a presentation on behalf of the petitioner, and this is considered in accordance with law.
Not some timeline, my lord?
Not necessary for timeline to Election Commission. Otherwise, when there is a timeline, they should consider and reject it.
Not any order passed, my lord. Liberty to come back. Liberty to come back.
Any the
Always
Election Commission order can always be challenged.
Lord, 3 days of refiling may be condoned. There's a 3 days of delay in refiling. That may be condoned.
That's it. Item 5.
If it may please, my lords. My lords, I do appreciate my predicament. The High Courts are burdened with pendency, particularly Allahabad High Court. But my lords, I'll be failing in my duties in not highlighting the grave hardship that I'm facing because of this pendency. I have a son who is 80% disabled. Please see, my lords. From July 22, my salary has not come. I'm earning only out of my two daughters I have, 18 and 27. Household is being run only by the tuitions.
Transferred post.
My lords, indeed.
Join or transferred post.
My lords, I did join. I joined the Lakhimpur Khiri and I went on medical leave because, my lords, he's a grown-up son. I have to nurture, take him. All I'm seeking is, my lords.
Get your salary. How will you meet the medical expenses of your
So
son?
that's what I'm explained to my lords. That my daughter, one of the daughters.
Prioritize your importance.
My lords, one of the daughters
Working in a
who's doing tuition.
This is important, or your employment is important.
My lords, if he's 80% disabled, my son.
We are going to request you as leader of the bar.
My lords.
You please survey in all the high courts.
My lords.
And submit a report what to do, because all high courts.
I quite see, my lords.
The tendency has gone high.
I quite see, my lords. But my lords, I just
fighting hard in prioritizing the matter.
My lords.
The problem is that if there is somebody, unfortunately, motor accident claim, he says, my priority because I have lost my brother or I am permanently disabled. I don't have any source of life where I go. Person who is in matrimonial dispute, they say matrimonial dispute has a lifetime.
Indeed.
We can't wait for becoming senior citizen. Please tell them to get. There are persons in custody, incarcerating, they say our criminal appeals are pending. These are all competing claims and each claim has its own merit.
Indeed.
To say that this matter should be ignored is
that individual, their grief is most.
Our only problem is that now in this system, then we leave it to the Chief Justice of the High Court.
My lords, I've moved 6 early listing application. If I may propose, I may move one more if the Chief Justice of the Honorable High Court could consider that.
You file an application.
I moved 6 of them, my lords. They mention my application doesn't come. I have showed the case status.
That's why we are saying, please go and file an application.
If my lords may just put that, I would be deeply obliged. My lords, it's only because of the disability of my grown-up son. To take him anywhere, to give him shower, I don't have the means to keep a medical aid. That's the